Joining us now live to discuss the latest NSA developments, it's Anthony Arend. He is a government and foreign service professor at Georgetown University. Anthony, thanks so much for joining us. What do you think, deal or no deal?
I can't see where any deal with Snowden makes any sense whatsoever. Obviously, I don't know, and we fully don't know the extent to which he has material that he hasn't disclosed, but it seems to me virtually ridiculous to say we would enter into a deal with him. I think people are right when they say if we're able to make a deal with Snowden, it's going to lead other people to follow the same sort of process, and we simply can't have it. His behavior, in my view, has been despicable. It's violated federal law, and it's not something that there could be any plausible deal on as far as I can see it.
Anthony, let me talk to you a little bit more about the judge's ruling today. He says the government does not cite a single instance in which the analysis of the NSA's bulk collection actually stopped an imminent attack or otherwise aided the government in achieving any objective that was time-sensitive in nature. Is this a blow to the NSA?
Well, I think it is a blow, but the one thing to remember, so this is a federal district judge, Judge Leon. What he's done is he's issued a preliminary injunction, and then he said, but I'm going to stay that injunction, meaning it will not be effective pending an appeal. So it's a major blow, but it's just the first start. I think what we have to see is how this case is going to play itself out in the Court of Appeals and potentially in the U.S. Supreme Court. What I do think is remarkable, though, is that Judge Leon has suggested that this bulk data collection that was taking place by NSA may in fact violate the Fourth Amendment. It may in fact be an unreasonable search, and this is the first time that a federal judge has been able to assert that. So the government is going to have to defend itself, but again, it's the first step. There's a long way before a final decision is rendered on this case.
And Anthony, we have an international audience, so walk us through this process, because it does take a long time before it ever gets to the Supreme Court, where eventually one would assume it would land.
Exactly. Well, what's going to happen next is there are going to be efforts by the government to take it to the D.C. Circuit Court of Appeals, which is the appellate court that deals with issues that are brought into the D.C. District Court. The District Court is the trial court, and that's the one that Judge Leon presides in. So it'll go before the D.C. Circuit Court of Appeals. There will be full oral arguments taking place there. Then that court will render a decision. Now, normally the way the court works is there's a three-judge panel. The three-judge panel will reach a decision, and then the government or whomever could appeal it to the full court, what's called an en banc decision. That would then be a separate set of oral arguments still before the D.C. Circuit Court of Appeals. Then, depending on what happens, the case could be taken to the Supreme Court. One of the either the plaintiff or the defendant could file what's called a petition for a writ of certiorari, giving the Supreme Court an opportunity to decide whether it wants to hear the case or not. The Supreme Court could say, we're not going to hear the case, we're going to let the decision of the circuit court stand, or we are going to hear the case, and then that would delay final resolution probably by yet another year. So there's really a long way to go before ultimately the Supreme Court weighs in and gives its final decision as to whether this collection, this bulk metadata collection, violates the Fourth Amendment.
And Anthony, we've been talking about the courts. There's also the Court of Public Opinion, and I want to talk to you a little bit about that. Democratic Senator Mark Udall came out. He's a critic of this program. He says that the bulk collection of Americans' phone records conflicts with Americans' privacy rights under the U.S. Constitution and has failed to make us safer. He's proposing that Congress take some action. Do you think this has changed at all the conversation in the Court of Public Opinion?
It's hard to say because I think the Court of Public Opinion is mixed. On the one hand, people are generally upset with what Snowden has done. On the other hand, as the extent of what the National Security Agency was doing is become revealed, people are concerned about that. Now, what has happened thus far has been under U.S. law ruled to be lawful. Again, this is the first case where there's a suggestion that it is unlawful. But the collection was done pursuant to a federal statute authorized by a judge on the Foreign Intelligence Surveillance Court, and so it would be putatively lawful. One of the things that the public could do is persuade Congress that we want the law changed. Whether this is lawful or not, whether it's constitutional or not, is one question. We simply don't like this law because we think it is too intrusive. We think it is too invasive. We think it is contrary to what we want to have, and so there could be a move in Congress to change the law. The problem is, right now, the U.S. Congress has been unable to do very much, and it's hard to see any kind of coherent movement to craft some kind of legislation which would overturn the legislation which had been previously adopted. Now, presumably, it's possible that you might have the more libertarian right uniting with the more civil libertarian left to reach some kind of agreement. But with the paralysis in Congress, honestly, I don't see a legislative end coming anytime soon.
Yeah, don't bet on it. Professor Anthony Arend joining us from Georgetown University here in Washington, D.C. Thanks so much.